24-hour-a-day access to his attorneys. He's in contact with them now. He's had an evening meal. He's in a situation where he's just waiting to hear what happens, and he'll be in contact and get that information from his attorneys.
Herbert Smalls was convicted of the murder of Stephen Honickman during the robbery of Honickman's jewelry store in 1991. Honickman's wife was also shot during the robbery. She survived. The state of Missouri was scheduled to execute Herbert Smalls on Tuesday of last week, but Supreme Court Justice Samuel Alito issued a 24-hour stay while the full court ruled on 2 petitions filed by Smalls' defense lawyers. The next day, the Supreme Court vacated the stay and the stay of a lower court ruling, which allowed the state of Missouri to carry out the execution. Smalls' defense attorney filed another appeal just before 10 p.m., arguing that the drugs being used in the execution were untested and could cause pain and suffering, while still waiting for the Supreme Court decision. The state of Missouri executed Herbert Smalls just after 10 p.m. that same night. 4 minutes after Herbert Smalls was pronounced dead, the Supreme Court denied his final appeal. Joining me now for an exclusive interview is Cheryl Pilot, the defense attorney for Herbert Smalls. I have to say, I'm surprised that an execution would go forward while there was any form of an appeal pending. Is this something that's common? Do you have to have a formal stay of execution in order to delay these things?
Well, Lawrence, it wasn't simply an appeal or a legal claim lodged in any court. There was a formal application for a stay of execution, which was filed in the Supreme Court and had been pending since before the order that removed the stay that we had in place at that time. So there had been a pending claim for relief accompanied by an application for stay that had been pending in the Supreme Court. There was no period of time in which we did not have a claim and an application for stay pending. And so I think it would be fair to say that we were not only dismayed but shocked when the execution went forward, despite our efforts to communicate vigorously with the attorneys at the Attorney General's office, and we communicated to them repeatedly that we had pending legal claims and an application for stay on file, and they were well aware of it. And the fact the execution went forward is deeply troubling to us.
But haven't they done exactly this in other cases prior to this?
They have, indeed, the last 2 executions prior to my clients, and the last one prompted a very critical dissenting opinion by a judge of the 8th Circuit, and we believed, frankly, that with that dissent making clear that at least, that judge had come out and said what he viewed as very improper, we thought that the state of Missouri would refrain from repeating that scenario. And we have now seen with the last 3 executions that while motions or applications for stay have been pending in either the District Court, the 8th Circuit Court of Appeals, or the United States Supreme Court, that despite those pending requests for a stay of execution that had not yet been acted on, that the state of Missouri went ahead and executed the prisoner. And we have been unable to find any other place where this has occurred. There have been a couple of scattered anecdotes out of other states, but those of us who do capital work on a regular basis are unaware of any other state where this has proceeded, as we now see, 3 times in a row.
Cheryl Pilot, thank you very much for joining us tonight, and I know that your job carries with it emotional loads that I don't think very many people understand, and I thank you for bearing those loads. The Constitution needs someone to do it. Thank you very much.